iBarristerschambers.com. I'm dealing with working in the United Kingdom. The information is correct at the time of recording, June 2014, but immigration law is fast changing, so you really must check the requirements of the immigration rules or consult an immigration lawyer before making any application. The law permits certain people to work in the UK without further permission. This can include persons admitted for settlement or with limited leave to remain in the UK with a view to settlement, refugees, and those granted leave under the provisions relating to humanitarian protection. It also covers others who are admitted without prohibition on their employment, for example, dependents of Tier 1 and Tier 2 migrants. EEA nationals can exercise treaty rights in the United Kingdom, and this includes working, doing business and investment. You don't need further permission for that. Otherwise, general visitors may not work whilst they're in the UK, and doing so puts them and their employers at risk of prosecution. Employers can also be liable for civil penalties. I'm going to give an outline of some of the categories under which prospective workers can seek permission to work, and I'll be talking about tiers. This refers to categories created by the immigration rules under which applications are made and visas are issued. The immigration rules are available on the UK Home Office website, and you should make reference to them in preparation for making any application. That site also contains guidance on the making of applications and on how immigration officials deal with those applications. Check the iBarristerschambers.com website for more details or for a link to the Home Office site and the rules. Exceptional talent, Tier 1. This is for world-leading or potential world-leading talent in science, engineering, humanities or the arts, or for entrepreneurs or investors. You need the official endorsement as such from a Home Office specified body. You may apply for limited leave, 3 years, which can be extended for 2 years and followed by a settlement application. These periods can be longer or shorter in certain circumstances. Family members living with you may also be able to apply for settlement at the same time. The application is made to the Home Office, who will contact the relevant endorsing body. The Home Office imposes limits on the number of endorsements those bodies can give in any particular year. This category is part of the points-based system of immigration rules, which lays down requirements to satisfy certain competencies. You can read more about these in the iBarristerschambers.com website or in the rules. Entrepreneurs, Tier 1. This is a category for one or two business persons who are seeking to start new UK business or join existing UK businesses. There's a minimum investment of £200,000, £50,000 if it's from a Home Office approved source. Various requirements apply to the money, including where it's held and its source. You can apply for limited leave, possibly extendable, and finally for settlement. An English language requirement applies under this category, and applicants must be able to show sufficient funds to support themselves and their families whilst they're in the UK. This category is also part of the points-based system, so certain other competencies apply. Investors, Tier 1. This is for people who want to make investments of at least £1 million in the UK. Generally, that money must be in a regulated financial institution and disposable in the UK. Different rules may apply for applicants who are of net worth £2 million or above and intending to borrow money for investment. You may apply for limited leave to enter the UK, possibly extendable, and finally for settlement, and no English language requirement applies under this category. It's also part of the points-based system of immigration applications. Graduate entrepreneurs, Tier 1. Graduates from certain UK higher education institutions who can demonstrate world-class innovative ideas can stay after graduation to establish business in the UK, and this leave normally lasts 12 months initially, but it can be extended, after which you have to switch to another category. Applicants under this category require endorsement from Home Office approved higher education establishment, and that endorsement has to confirm a credible and innovative business idea. Again, the number of endorsements such establishments are allowed to give in any year is capped by the Home Office. There is a requirement to show funds are available for maintenance and accommodation, and again this category is part of the points-based system. Tier 1 migrants' family members. Spouses, civil partners or unmarried or same-sex partners and children under 18 of Tier 1 migrants also require entry clearance, and they too can apply for the relevant extensions and for settlement. Sole representatives of overseas firms. This is a category which relates to senior employees, representatives of firms whose headquarters and principal places of businesses are outside the UK and which have no UK branches, subsidiaries or representatives. Its aim is to allow the firm to send someone to the UK with a view to establishing a first commercial presence here. The Home Office will scrutinise the firm quite closely to make sure that it's a genuine commercial enterprise, and particular requirements apply if that firm has been in business for less than 12 months. The requirements for this category are detailed, and you should pay close attention to the rules and guidance or seek professional advice about the application of this category to your circumstances. Leave to remain will initially allow you to remain for 3 years, after which it can be extended, and after 5 years in this category you can apply for settlement. Job offer held, Tier 2 General. You can apply to enter the UK if you already have a job offer from a licensed UK-based employer. The job must be skilled and must either appear on the list of shortage occupations or be at graduate level. You'll need a certificate of sponsorship from a licensed UK-based sponsor, but that's not all. As with other categories under Tier 2, the immigration rules require that you score a specific number of points from different areas. Generally, they are attributes, sponsorship and salary, English language and maintenance. There'll be a condition that you have no recourse to UK public funds, and generally you're able to work to supplement that work for which you were granted leave if it's outside normal working hours for that original work. This must be work which is also on the shortage occupations list, and there's a 20-hour per week maximum. IntraCompany Transfer, Tier 2. Existing employees of multinational companies can obtain leave to enter after being transferred to a skilled job in a related UK entity. This will be a job at graduate level or above, which cannot be filled by a worker from Britain or the EEA. You'll require a certificate of sponsorship from a licensed UK-based sponsor. Again, this is a necessary but not sufficient condition, and the immigration rules require that you score a specific number of points from those other areas mentioned earlier. The categories are long-term staff, where you've already been employed by the company for at least 12 months and you'll be filling a post lasting 12 months or more. There are maxima which apply depending on the salary. Short-term staff, where you've already been employed by the company for at least 12 months and will be filling a post in the UK for no more than 12 months. Graduate trainees, where you're a recent graduate intending to come to the UK as part of a structured graduate training programme with progression towards managerial or specialist roles. And skills transfer. This is for graduate employees who are transferred either to learn or to impart skills in the UK. You can expect to be granted leave for 12 months under this category, and there'll be a condition that you have no recourse to public funds. Minister of Religion, Tier 2. You can apply under this category if you're a qualified religious worker within a recognised religion, or if you minister or perform pastoral duties, even if they're not full-time. This can mean, for example, leading worship or providing religious education to children. You may be, for example, a member of a monastic community or a missionary. You'll need a certificate of sponsorship from a licensed UK-based sponsor. As with other categories under Tier 2, you're required to score a specific number of points from different areas. For example, attributes, sponsorship and salary, English language and maintenance. The sponsor will generally have to confirm that your employment will not be displacing or denying employment to a UK worker, and they will normally have to undertake to support you and your family throughout the period of sponsorship in the UK. You can expect to be granted up to 3 years leave to remain with the possibility of an extension and settlement. There'll be a condition that you have no recourse to UK public funds. Applications to extend permission can be made, and they should be made just before the initial period of leave to remain comes to an end. Any delay can lead to you being in breach of immigration law, and that will harm future immigration applications. You'll have to show a further certificate of sponsorship for an extension, and you have to demonstrate also that the requirements of the original leave to enter have been met. Sportspersons, Tier 2. This relates to elite sportspersons or coaches, internationally established at the highest level, who wish to be based in the United Kingdom. Permission will require an assessment that you will make a significant contribution to UK sport at the highest level. You'll need a certificate of sponsorship from a licensed UK-based sponsor, and the immigration rules again require that you score specific points from a number of other areas. You must have the approval of the appropriate governing body of your sport, and you can expect to be granted leave to remain for up to 3 years, with a possibility of extension and finally settlement. There'll be a condition that you have no recourse to UK public funds. And again, extension applications are possible and should be made just before the expiry of the first period of leave. Creative workers, Tier 5. If you're a creative artist, performer or entertainer and you want to work in the UK for up to 12 months, you can apply under this category. You can apply alone or you can apply with your company. You must have a sponsor who operates or intends to operate in the creative sector in the UK, and you must be able to, or you will be able to accept additional work of up to 20 hours per week within the same sector and at the same level as that for which your certificate of sponsorship was issued. Sporting workers, Tier 5. If you're a sports person internationally established at the highest level in your sport, or your employment in the UK should make a significant contribution to UK sport, you can apply to work in the UK for up to 12 months under this category. If you're a coach, you must have suitable qualifications. You must have the support of a licensed sponsor, which will be a sporting body, a sports club or events organiser, which operates in the United Kingdom sporting sector. You must be able to accept additional work, or you will be able to accept additional work of up to 20 hours a week within the same sector and at the same level as that for which you were granted permission. Charity worker, Tier 5. You can apply under this category to enter the UK to undertake up to 12 months voluntary field work directed by a charity and related to the charitable purpose of your sponsoring organisation. Sponsors licensed to support such applications will generally be UK registered charities. Religious workers, Tier 5. This category may apply if you wish to perform religious rites but not carry out the pastoral duties already discussed earlier in the context of Tier 2 Minister of Religion. You can expect leave to remain for 24 months under this category, and you'll need the support of a licensed sponsor. This will be a genuine religious institution and generally a registered charity too. The sponsor will, amongst other things, have to certify that your employment will not displace UK workers. I hope this has been useful. If you want to know more or want to contact me or another immigration barrister, go to our website iBarristerschambers.com, and good luck.